Good morning. Are you Carrington Scott?
Yes, ma'am.
And this is 25 DCCR 0538. Mr. Scott's charged with robbery. Mr. Burbank?
Your Honor, I have reached out to Mr. Smith. I understand what's going on. There is a video that is missing, and he was attempting to try to get it. The court could do two things. It would probably be dispositive of this case if it received, it's a convenience store robbery, and some of the cameras were.
Right off the bat, we see Carrington Scott step up to face a robbery charge. But here's the twist. The key evidence, the convenience store video, is missing or erased. That single detail could make or break the entire case. Can you imagine? A robbery trial turning on whether a security camera was recording?
Missing.
Okay.
The tape. If you want to reset it for a couple of weeks, I don't know when Mr. Smith will be back.
I'm sure Ms. Malfino or Mr. Nichols can
We
step
can
in.
handle it, Judge, and I just want to let the court know, Mr. Smith has documented that he did reach out to the detective on August 12th. I'll be happy to follow up.
Okay, thank you, Ms. Malfino.
The
So we'll
missing
just,
convenience store video, some of it was already erased, so I agree it would be dispositive.
okay.
Be dispositive of it. I mean, he's rejected the 15 years from Mr. Rojas, Judge.
All right, we'll just do maybe about 3 weeks. That'll give Mr. Smith, when he gets back, or Ms. Malfino, sounds like she'll step in and try to take care of getting whatever information they can, so that we'll, if they have it, you can see it. If they don't have it, then we'll figure it out from there as well.
The defense immediately points out the missing footage and suggests pushing the case back. The judge agrees. This moment highlights how fragile cases can be when evidence disappears. One erased tape, and suddenly 15 years on the table might be reconsidered. Do you think missing video should automatically weaken a robbery charge, or should other evidence step up?
All right, thank you, Ms. Malfino.
See you, Mr. Scott. I think that's all I have.
It is. Thank you, Mr. Burbank. Mr. Lewis, you have Derek Ardwan. It's a sentencing. Good morning. Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25 DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of 6 years in the institutional division of the Texas Department of Corrections. I have received.
After quickly wrapping up Scott's case, the courtroom shifts gears, and the stakes skyrocket. Next up, Derek Ardwan, already convicted of a second-degree felony sexual assault, facing his sentencing. This isn't just about missing footage anymore. This is about accountability, power dynamics, and the law drawing a hard line.
The pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
None from defense, other than that. Something I'll clear up my argument.
Okay,
I have nothing, Judge.
go ahead.
Well, Judge, when you review the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that seems like he was minimizing or still deflecting some of his responsibility in what happened. I did speak with Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying, because there was 2 people from probation there at the time.
Yes, sir.
And so as the second person started to intervene, he understood. And so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation where someone was underage or anything like that. She was definitely of consenting age. Being in a relationship with him, they started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they worked together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point where she couldn't give consent, legal consent or anything during the activity.
Ardwan's defense argues he's remorseful, painting the situation as consensual and emphasizing that the victim was not a minor. But let's pause. The fact that intoxication was involved legally changes everything, because consent under the influence doesn't hold up in court. Do you believe his remorse is genuine, or is it damage control at sentencing?
I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001, since 2001. So since he was in trouble that one time, or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of his family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of it. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision in the situation. I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he would be able to get any of the attention or that he needs through any sex offender classes or through their registration, as well as I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking the court to consider deferred adjudication.
The defense leans hard on his clean record since 2001 and family support, even asking for probation instead of prison. But here's the contradiction. If he takes full responsibility, why downplay the victim's intoxication? That gap in his story is glaring. Have you noticed how often defendants claim accountability, yet still push blame to the side?
In the situation with Mr. Ardwan.
Thank you. Ms. Malvino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, but the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap, but defer to the court's discretion, of course.
Thank you.
And if I just may confirm, in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I think we did that at the plea.
Okay, just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Malfino that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years, there's no treatment, there's none of that I think would be helpful. And so I think, to me, the better and maybe even more difficult thing for you is a probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other.
Then comes Judge West's decision, and it's a curveball. Instead of sending Ardwan to prison, she orders 10 years of strict probation with mandatory sex offender treatment, registration, and a $1,000 fine. But here's the kicker. If he violates probation, she can hammer him with up to 20 years. That's not leniency. That's a ticking time bomb.
Stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years or I violated and I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand?
The judge lays it out bluntly. Treatment, full admission of guilt, no contact with the victim, and 0 excuses. She even strips away the safety net of the original 6-year cap. Her message? Probation isn't mercy. It's a test. Fail, and the consequences multiply. Do you think probation in a case like this is tougher than straight prison time?
So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Now, obviously, a part of this probation is that you have absolutely no contact and no communication with the victim. And so if there's some relationship that you're still having with her mother, it cannot be at a place where she is. You cannot go to wherever she's working. If you go into a restaurant and then she comes in after you, you're the one who has to leave. It's up to you to remain away and not have any contact or communication. You understand? Yes, sir. All right, good luck. Thank you, Mr. Lewis. Sorry, that goes with that. Mr. Jeffries? Mr. Jeffries, you have Jesus Ibarra. Morning.
This hearing is a reminder of how unpredictable courtrooms can be. Justice isn't always about punishment. Sometimes it's about structure, consequences, and a chance for change. But whether that chance is used or wasted, only time will tell. What do you think? Did Judge West make the right call? Drop your thoughts in the comments, and don't forget to like, share, and subscribe for more real courtroom breakdowns.